Good afternoon to good afternoon to everyone. I hope you're able to see me and you're able to hear me. If you are able to see me and hear me, give us a yes. So at least we know things are okay. We had some slight technical issue to connect to the live session, so we managed to resolve it. And are you all able to hear me and see me? Yes. Okay. Good. So welcome to our our another edition to our webinar series. Today we are going to share and discuss on managing and safely terminating employees with medical conditions. We first manage them first, but if it gets out of bound, then we need to look at what's next, which may include ending their employment in a proper process. So from now till about 5 o'clock, we might end a little bit earlier because today's webinar is not too long. The slides are lesser than what we had in the previous webinar, so it might be a little bit shorter. But of course, if you have a lot of question and answer, we can stay until 5 p.m. Right? So from now till 5, please pay attention, put your phones away, and focus, ask question, and what do you call this? And pay attention. Okay. So let me just give me a short while. I just want to see. Okay, hold on a second. Okay. So we have roughly about 332 of you all on, live today. We had about 800 plus who registered. So I'm sure the rest will be joining in. So nevertheless, we will start now so that, we can move on and we can finish on time. Okay. So before I begin, my name is Arul. I'm sure quite a number of you all know me if you have joined all the previous webinars or attended trainings, attended the masterclass, attended the conferences, or if you're in Facebook group. So my name is Arul, so I wouldn't want to introduce myself further. For those of you all, if you need to know, if you want to know more about me, I will share these slides later, so you can get a copy of the slides and read a bit of my background. If you all need to contact me, my contact email and my phone number is at the bottom. But please don't, bully me lah. Sending me messages, private messages. I got this problem, that problem. I get lots of private messages and emails, but I can't reply all. So if you have an issue you would like to ask, please, ask in Facebook group, or please ask in our group, our public WhatsApp. We have got 12 public WhatsApp group, so you can join any of this group, one member, one group per member, and you can ask there. So we have got many other experts, fellow practitioners, experienced HR folks who can also help you out. So if you have any questions relating to your work, employment law, disciplinary matters, whatever issues you have, and you need some advice, it is good to raise it in Facebook or in our public WhatsApp group. So now, before I move on to my slides, I would like to just share with all of you all that our next Malaysia HR Tech and Innovation Conference and Expo will be held on 22nd and 23rd September at Nexus Bangsa. Now, for those of you all, if you have joined us in our previous HR Tech conferences, whether it was in Sime Dhabi or the one last year we had in Nexus, similar model, similar crowd. Maybe this year will be a bit more because it's 2 days. And for those of you all, please attend. It's free. We provide breakfast, we provide afternoon break, lunch. You can turun to the cafe and eat. It's a free conference, so we can't provide lunch. Otherwise, it's very costly for us. So for all of you all, if you're in Klang Valley or if you're able to make it to Klang Valley, do join this. As usual, we'll have a lot of local speakers, international speakers. You can visit, close to 100 exhibitors and sponsors. We have got some demos, some side activities. And this time, for the very first time, we also have the HR Tech Award that we're going to give out to individuals, to companies that have implemented new tools, embrace technology to make HR processes better. So we will be reaching out to you as well for nominations. And this award is free. You don't need to buy tables, spend a bit of money to be there, etc. It's free. So remember, block your date, 22nd, 23rd September. It'll be at Nexus from 8:30 right up to about 6 o'clock. And hope to see all of you all there. So those of you all, if you like to register, there's a link in the slides. Later part, after this webinar is over, I'll be sharing these slides. And for those of you all, if you are a sponsor and exhibitor, if you like to exhibit or sponsor the event, you can write to Sophie at malaysiahrforum.com. Now, a bit of ground rules before I begin the slides today. The slides that you are seeing will be shared in our HR Forum Facebook group. Now, all of you are in the group, so you are a member already. So we will share this there. So my advice to all of you all is this. Please listen to the webinar first in full. Sometimes, we are so quick to ask questions, but have not even presented yet, or we have not even addressed the topic yet. Please listen to the webinar in full. Then you raise the question, because then you will get the context, the answer, the context, the logic. Usually, sometimes we are so quick to ask, but we have not got the full concept yet. So it is always good to listen fully, understand the concept, understand the logic, understand the intention of the law. What does the law says? What the law says, whether it's can or cannot, etc. And then, ask. It is also good to do basic research. Now, many of these topics we have discussed in Facebook group as well. So for those of you all, if you are still in the learning stage, you're still trying to learn how to manage these issues. So it'll be good for you to get into the HR forum group and ask for yourself, right? Read for yourself and so on. So I would encourage all of you all to listen carefully, listen closely, understand the logic, understand the concept, understand the intention of the law, and then ask your question. And I will pick up all your questions once I've presented the slides. Okay, as usual, before I move on, this is a small mantra to tell everyone that compliance, right? If we, compliance, that means when we follow the law, it is cheaper than when we choose not to follow the law. So if you think compliance is expensive, try non-compliance. So very often we try to do things shortcut here, hide there, cut here, cut there, etc., thinking that we can get away with it. But you never know. One day when the law catches up with us, the penalty, the consequences, the embarrassment, the image that we have built, can go spiraling down the drain. So remember this, we can do all the charity that we want in the world. We can paint the sky blue. We can go and clean up rivers, collect rubbish, go to old folks' home, do some activity, do some charity, give something, etc. But tomorrow, when your name appears in the paper, for example, company X or whatever company, so-and-so company, did not treat their employees well. So-and-so company did not pay their workers well. Now, then all the charity work that we have done goes down the drain, right? So, in other words, this statement by the US Deputy Attorney General at that time, Paul McNulty, he says this: if you think compliance is expensive, try non-compliance. And I would always encourage HR practitioners to run through this one slide when you are presenting any HR topics, a change to their policies, procedures, and so on and so forth, or in your regular town hall, so that we keep reminding ourselves that compliance is cheaper than non-compliance. And so I'm going to go into the topic today. How do we manage employees with medical conditions? Now, it is very common, right? It happens. Today, an employee starts working for you. They are quite healthy. And over a period of time, maybe after a couple of years, they become unwell. And then they start to show symptoms. And then they start to, take sick leaves and so on and so forth. So how do we manage that? What do we do when the employee at one point, maybe could be many, many years down the road, they become extremely unwell and they are not able to perform their job anymore? They are constantly on sick leave, long hospitalization leave, etc. So what do we do, right? How do we manage them? And what does the law says about, employees who are unwell? What is the company's obligation? What do you need to do first? So similarly, for example, in retrenchment, if the company is not doing well, should we retrench the workers first? Or do we need to look into other factors? Now, if you read, for those of you, if you've joined the previous webinars, if you read the guideline on retrenchment that is produced by the Labour Department, as well as the Code of Conduct for Industrial Harmony, what does these two pieces of document says? Before you retrench, right, look at reducing the work hours. Look at reducing, overtime. See whether you can retrain this employee, redeploy them. Now, once you have done all of this, you have retrained, redeployed, look at reduction of work hours, reduction of OT, etc. Look at a pay cut. Now, after doing all of this, the business continues to struggle. Then you retrench them. So retrenchment is not the first option. Retrenchment should be the last option, right? You can offer VSS, if you want to do a headcount reduction, you can offer VSS, but an employee can choose not to participate in the VSS. It does not mean you offer VSS, the employee must accept. The employee can choose not to accept VSS. So what do? Right? So if the employee accepts VSS, well and fine, good. Now you have lesser employees because some of them have taken the VSS package and they've left the company. What if an employee do not want to accept VSS and the business is struggling? So what does the law say? What does cases say? What does the Code of Conduct for Industrial Harmony say? What does Labour Department's guideline for retrenchment says? Reduce workforce, look at reduction of OT, reduction of work hours, retrain them, redeploy them. Maybe those people who are going to retire, see whether you can, go for early retirement. Of course, there's some money involved there. So you do all of this first. And if you still cannot, then you retrench them, right? So retrenchment is the last straw. What about poor performers? If you have a poor performer, can you straight away terminate them? You can't. What does case law says? Put them on some kind of trial. We call it, some kind of correction plan. We typically call it as PIP, Performance Improvement Plan. Put them through PIP. See whether they can improve. See whether we can, give them support, give them guideline. Give them support, give them advice, do whatever you can. And if it come to a point, they still cannot meet your performance level, then you terminate them, right? After PIP. So even termination because of poor performance, there's certain processes to observe, right? So now, similar context to medical. If an employee is feeling unwell, they've been taking sick leaves after sick leave, can you straight, remove them? No. You still give them some time to recover, do whatever you can, etc. So now, when you read cases, if you read cases that has gone to the industrial court, and what does the court say, right? So employers, you may terminate the employee on medical grounds if they are no longer able to fulfill what their contract says. The contract says you got to work, but they are not able to work, right? For whatever reasons, due to medical illnesses. So they can't perform their job function as what it is supposed to be. And their condition is, has gone from bad to worse. And the prospects of recovery is so slim, right? Extremely minimal. But what do you need to do? You as an employer, you are expected to be reasonable. So I hope you all can just write this thing down, right? I hope you have a paper to write down, take notes. So employers are expected to be reasonable. That means you got to look into certain aspects, see what can be done, be reasonable. And the second thing that you got to do is show that you have exhausted various options and actions, right? Be reasonable and show that you've exhausted various options and actions, right? And if you decide to terminate an employee, right, the termination may be unfair if you have not made sufficient and necessary inquiries. That means you have not found out what exactly is his issue, right? Is there a chance of recovery? Has the doctor checked on him? What is the doctor's comment? Now, you and I, we are HR practitioners. We are not medically trained. We cannot read medical reports and decide, oh, I think this issue, right, I don't think he can recover. Now, you and I, we're not medical experts. We need to get a medical expert to advise us whether his condition, there's a chance of recovery, or recovery is going to be slim or minimal, right? So you got to make these inquiries and evaluate all surrounding circumstances before we arrive at a conclusion or a final decision. So let me repeat again. What are you expected to do? Number one, be reasonable. Number two, show that you have exhausted various options and actions, right? I'll show you what is it later. Number three, please find out what is the issue. Get doctor's input, not your input. Get the expert who's a medical doctor, a medical practitioner, a specialist, etc. Get their input. And the fourth is to evaluate all surrounding circumstances. So you got to do all this. You cannot just, oh, the employee is not feeling well. He has got, whatever illnesses. He has been on MC for some time. Let's terminate him tomorrow. You can't do that, right? Please observe these 4 points. Be reasonable. Show that you have exhausted various options and actions. Make sufficient inquiries. Evaluate all surrounding circumstances. So this is what you got to do. Okay, and now, what are the factors to look at, right? What are the factors to look at? The factors that you got to explore, right? Again, this is not a tick box, right? You tick, 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 okay, I'm done. No. What are the factors? Look into the employee's nature, the nature of his illnesses, how long he is likely to be away, right? How long is he likely to be away? And what is the nature and functions of his job, which this particular condition will make him handicapped. He can't not able to perform. How long is he going to be sick? Right? It keep recurring. Today he's okay, tomorrow he's not okay, then he's okay, then he's not okay. So this thing goes on and on, right? And what is the impact of his absence? If he's absent, who's going to do the job? What is the impact on other employees? So you got to evaluate all this. Now, let me remind you, or let me advise you, this is not a tick box. Tick, 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 right? Oh, I'm done with my job. No, this is to give you an idea. What are the areas to examine? What are the areas to explore, right? For example, the nature and functions of the employee, his job, and what is the impact on the company. So let's say in a very small environment, a small company, you only have about 20 staffs, and he's the only driver, right? For example, you need to drive the van to deliver goods. He's the only driver in the company, and he has been away for some time. So the impact on the company is extremely big, right? Because he's the only driver. Nobody else is a driver. He's the only one with that commercial vehicle driving license. Now, the impact is huge. But if your company is sizable, you have got 400 employees and you've got 20 drivers, then the impact on your company is much lesser than the first case. So this is what you got to evaluate. Now, I remember there's also cases where the court asked the company this: your company is so huge, you're trying to tell me that this one employee, because he's unwell, is going to cause the company's business to be affected, right? So these are the kind of factors that you got to consider. And so this is a simple medical process, a medical management process designed by me many, many years ago. I think almost about 10 years ago, or 11, 12 years ago, when at that time, we were looking at how do we manage employees' medical condition. This is to give you an idea. Again, don't take this as a process flow. Okay, I follow this, right? A simple guidance. Where do you start? How do you go about it? And where it ends. So now, typically the issues that you would have are the employee would have terminal illness, chronic illness. For example, cancer, stage 3, stage 4, diabetes, probably the toes is gone, really at a bad situation. Or if the employee met accident, or he got into an injury at the company's premises, right? Or maybe while on the way to work, going back from work, etc. Or he met an accident during his private time, during his leisure time. Maybe on a weekend, met an accident, or maybe played football, broke his leg, climbed the mango tree and fell down, broke his hand, etc. So these are some of the non-occupational injury. Frequent MCs, on and off MC, every now and then MC, right? Or the employee takes long MCs, and there could be also other issues. So other issues could be like mental health illness. So please ask me if you have any questions. I will share with you my thought perspective. So these are the illnesses. If there's anything that is not here, it could be under others. Now, what do you do when employee has any of this? Now, let me also tell you this. The first 3 scenario, terminal illness or chronic illness, workplace accident or injury, non-workplace accident injury, usually an employee cannot fake this. They cannot, he will not go and meet an accident just to avoid work, right? I don't think anybody will do that. Anybody with a, wise mind will not do that. You know what? I don't want to come to work. I will go and get myself into an accident so that I can get 1 month MC. Nobody will do that. The issue that you probably have today are those people who frequently take MC, take long MCs, and it's hard to get hold of them. These are your common issues, or your issue number 1. So irrespective of what issues they have, Now, I'm just giving you an example. Okay, sorry for the technical glitch. Are you all able to hear me and see me now? If yes, just say yes. And hear me? Okay, good. Screen is paused. Okay, let me repeat again. Yeah, let me repeat again. so that maybe some of you have missed it, but let me repeat again. Now, when we look, so this is a simple medical process, funnel, or whatever you call it, to give some guidance, the flow from the time it starts until you are able to, board this employee out safely. The common issues that we have are this: terminal illness, chronic illness. These are, cancer, diabetes, illnesses where they are really struggling, right? Terminal. That means there could be a possibility, they may not be able to survive as well. So terminal illness, chronic illness, workplace accident, right? They met accident at the workplace, or maybe while going back to work, coming to work. Non-occupational injury, they may have played football, broke the leg, broke hand, motorbike accident, car accident, climbing a mango tree, fell down, broke their hand, etc. Frequent MCs, on and off on MC, etc. Long MCs, or others. Others could include mental health issues or anything that you don't see from the top list. It could be under others. So these are the common issues that you face. The first three, which is a terminal or chronic illness, workplace accident, or non-workplace injury, I don't think any employee would fake it, right? Just to avoid work, right? I don't want to work. I want to have 1 month off. Why not? I go and break my hand and, get doctor to put a cast and I don't go to work. I don't think anybody will do that. So this thing happens, right? If it happens. But the concern, I agree, would be when employees are taking MCs, right? This is one of the biggest issues I think most companies have. But let me tell you, there is a way to overcome this, provided you're willing to do something about it. So what do you do? When the employee exhausts their sick leave or hospitalization leave or end hospitalization leave, what do? You send them for a medical assessment. You need to appoint either an OHD or your appointed doctor. OHD is always preferred. Occupational health doctor is always preferred. Or a specialist somewhere. You decide, right? Appoint them and you send them for medical assessment. You tell the employee, now the company, as per our policy, require you to go, to be assessed by our medical appointed doctor. So you got to spell this out in your company policy that, if the company wants you to go for medical assessment, you got to go. Failure to go could be deemed as insubordination, right? Remember in the previous webinar, I mentioned this. In the case of Niao versus Sungai Wang Plaza, the federal court said this, any instructions by the company, if it's reasonable and lawful, must be obeyed by the employee. So if I tell you now, Janet, please go for the medical assessment because you have not been coming to work, etc. So Janet has got to go, right? Am I being reasonable? I think I am, because you're not been coming to work. You keep giving us sick leave. I want you to go and be assessed by a doctor, and I'm paying for it, right? So make them go. So and always tell this to employee, and I also tell this to HR practitioners. Why do you put the burden on your head? If an employee is not coming to work because of medical condition, HR takes all the burden on your head. The company takes all the burden. What to do, how to do, etc. Now the burden, don't put the burden on your head. You tell the employee this. Now listen carefully so that I can relieve your burden a little bit. So just now we had a debate in one of the group. Employees saying that dealing with this employee, I became mental myself. So let me de-mentalize you, right? Now tell the employee this. Now look here, so and so, you have not been coming to work. You've been taking long MCs. The company is concerned, right? We are concerned. Why are you taking MCs? The employee will probably tell you this. Hey, MC is my hak saya. Yes, MC is your rights. But we are wondering, why is your MCs frequent? Yeah, MC is your right. You got 14 days of MC given by Employment Act. But remember this, MC is to be taken when the employee is genuinely ill. Genuinely ill. So we have a concern because when we see the trend, you have been on and off MC. So we want you to be assessed by our doctor, right? Dr. John is our OHD doctor. Please go and see him. I've already made an appointment. We will pay the bill. And please bring all your medical report to see Dr. John. and Dr. John will, assess you. He may also speak to your doctor at wherever you're getting treatment, right? Giving the permission, you can call your doctor. And Dr. John will advise the company whether you're fit to work or you're not fit to work. Now, start doing this. But if you now tell me, can we ask the employee to find his own doctor? Then you have no control. Can we send the employee to the normal GP? Again, OHD is a bit more qualified compared to a GP, because GP, they're general practitioners, right? OHD is a specialist, right? I would encourage OHD, don't try to save this money. So ask the employee to go for assessment. And now, let's say now I've got an employee called Janet. So Janet has gone for assessment. She has brought all the medical reports. Remember this, the burden is not on you. You tell the employee, you please bring all the medical reports, right? You bring your reports, present to Dr. John. Dr. John will study it, make an evaluation, speak to your doctor if necessary, and advise the company whether you're fit to work or you're no longer fit to work, right? So do that. Now, Dr. John has done the assessment, and he's informed the company that employee is fit to work. So what I will do, I will give the employee either a letter of advice or a counseling letter, whatever you call it, right? Letter of advice would be good, saying that, dear Janet, you have been assessed by Dr. John, and based on the assessment and based on all the evidences produced by you, so you produce evidence, not for me to go and do PhD research to prove why you're not coming to work. So based on the evidences you have produced, Dr. John says that you are fit to work. So please improve your attendance. If you can just do that, except for the first three, remember, terminal illness, workplace accident, if the guy has broke his leg, he's wearing a cast, nothing much you can do. But frequent MC, long MC, I can tell you, it will start to show a tremendous reduction by just doing this step. So send them for assessment. Now, you can, for those people who are taking long-term MC, they don't have any chronic illness. They're not on long-term medication, etc. Just want to not come today. Why not? Why you didn't come to work? Fever. Why you didn't come to work? This one, ceret beret. Why you got flu? Got headache. Now, you do not know whether these people are genuinely ill or are they sick. So by doing this, and then what do you do next? You can even confine them to a particular clinic. So no more going around getting MCs. So you can tell the employee, dear Janet, because you have been, doctor says you're fit, starting tomorrow, we will only accept MC from Dr. John's clinic. No other clinics. We are paying for it. Right? If you are in town, you must go to Dr. John's clinic, right? And get Dr. John to assess you. So by doing that, you are now making it harder for them to go around getting MC. Now, what happens if Dr. John's clinic, right? Listen carefully. What happens if Dr. John's clinic, your office is in PJ, Dr. John is in PJ, but you're staying in Kajang, right? Kajang to PJ can be easily 45 minutes to 1 hour. So are you trying to tell me that the employee must travel all the way from Kajang to PJ to be checked or to go and see Dr. John? No. If the employee is in Kajang, you can tell the employee, get your MC from the nearest clinic in Kajang, but when you come back to work, please get Dr. John to endorse your MC. I will pay for it. Get Dr. John to endorse your MC. So now you're making it harder for them. Are you being evil? No. You still go and see your other clinic, get the clinic to assess you, and you come and see Dr. John for endorsement. I'm paying for it, right? So now you are making it tight for them to maneuver. You're making it tight for them to play a fool with your medical benefits. Next, for those cases that is genuinely ill, they met an accident, they are wearing, they're on crutch for time being, they're wearing a cast. So what happens if they cannot come back to work? They've completed their 60 days. They've exhausted their annual sick leave. So they still cannot work. You can either, if they are able to do basic job, maybe doctor says that, okay, Janet is fit, but Janet is still recovering. Janet can do light duty, or if you can modify her duty. So if you are able to modify their duty, if they are able to give them a light duty for a short while, give it to them. Again, keep it black and white. Write to them saying that, dear Janet, as per doctor's advice, that you are in the recovery stage, you can do light job. The company do have this job for you for next 3 months. Now, this is not a long-term arrangement. So please remember this. State it clearly. This is not a long-term arrangement, only for 3 months. We're going to temporarily modify this job for you. So at end of 3 months cannot, you can pull the job back. Remember, black and white, please. Or the employee still hasn't recovered and they cannot do light job, or maybe you don't have a light job, right? If you don't have it, don't create one, right? So you don't have a light job and they still have not recovered yet. They continue on unpaid leave. They rest at home, unpaid leave. And there could be also a scenario where once they have exhausted their sick leave, let's say for example someone met an accident and they were on crutches for 2 months. After 2 months they recovered, but not recovered, but they are okay now, but there's a plate fixed in their leg. For example, those people who broke their leg, motorbike accident. Now, so this guy now, he limps to work, right? He limps to work. Can he go back to his old job? Maybe if it's a table and desk job, yes. But what if he's a technician? He needs to climb. He needs to carry heavy stuff. So there could be a scenario where some of them recovered, can go back to their original position. Good. Some of them, the recovery, that's it. They cannot go back to old job because now, as a technician, I'm now limping. I can't carry heavy stuff. I can't carry, I cannot climb to the roof, cannot climb to the chimney, for example, right? Cannot climb to the exhaust. So what do? Then you got to decide whether this employee can go back to, can be, if you have a modified job permanently, you're able to give him a permanent modified job. Or if you have a permanent light job, if it's available, give it to him, right? Put in the contract, put into your letter. But if they cannot, then continue unpaid leave. And some organizations, they also have prolonged illness leave. 3 months full pay, 3 months half pay, 3 months no pay, or could be 4 months full pay, 2 months no pay, whatever your policy is. If they qualify for prolonged illness leave and you're able to give it to them, good. So they are not working, they're on prolonged illness leave. Some cases, they may also qualify for SOCSO rehabilitation, right? SOCSO has their rehabilitation hospital. They qualify, they go for it. I think it takes about a month. Now, if let's say after PIL, they still cannot recover, then continue unpaid leave. If you have a light duty for time being, give it to them, right? Again, assess them, right? Again, send them back to Dr. John, right? For Dr. John to assess, so that Dr. John can see whether their condition is improving or stagnant, or it is, deteriorate. That means becoming bad to worse. So let Dr. John assess them. And finally, right, end of this process, maybe now they've recovered. After 7 months of unpaid leave, resting at home, recovery, now they've recovered, they can go back to original position. Or the recovery is limited. For example, the case, after 6 months, he was using crutches. Now he can walk, but he limps. He cannot go back to his original position. But you have a job that he can do. It's a modified job, right? A light job. So if you have it, give it to them. Now, after this process, after 6 months, 8 months, whatever period, right? After this entire process, the employee cannot go back to his original job. He also cannot do any modified job, or you don't have a modified job. Then you are left with no other options except to frustrate his contract. Or in other words, you terminate his contract on medical reasons. If they qualify for SOCSO, they go through SOCSO bought out, they also exit via that route. So that's the end process. At the end, what do you do? Now, from the start till the end, it can take easily 12 months. Remember this? Don't rush. Give them opportunity, time to improve their medical condition, right? Explore all options and actions. So it takes, easily a year. Can you terminate them after 3 months? To me, you're asking for trouble, because how do you know the person? can the employee recover in 3 months, right? So this process, end to end, I would advise 12 months. Every quarter, that means every 4 months, send for an assessment. First 4 months assessment, second 4 months assessment, the next quarter assessment, the final quarter assessment again. Then you decide. So it takes easily a year. And why should companies worry? Should you worry? The employees are unpaid leave. You're not paying salary. Unless you got prolonged illness leave, then of course you got to pay something out. But if you don't have prolonged illness leave, they are on unpaid leave at home, right? So this is a simple medical process funnel. So this can give you a bit of guidance. What do you do from the start until the end? But as I said, I've just mentioned, send them for assessment 4 times. Every 3 months, 1 assessment. If you want to do 4 months, I leave it to you as well. So 4 months, 1, 4 months, 1, 4 months, 1. So 3 assessment in the 12 months. Or you want to do it every quarter. Because why? You also want to know what is the employee's condition. Now, as HR, I mentioned this earlier on, we are not medically trained. You and I, we cannot read medical reports and decide on our own whether he's recovering or not. And you also cannot call his doctor. There's always a doctor-patient privilege, right? Confidentiality. You cannot call the doctor, okay, Dr. Sam, my employee Janet, can she work? You won't have the ability to call because the doctor cannot disclose your employee's condition because the doctor and the patient, they've got this confidential privilege. That is why you send them to your doctor and you tell the employee, please present all your medical reports to Dr. John. Let Dr. John assess your condition and he will advise the company, right? So that's what you could do to manage this situation. Now, let me just share with you a couple of previous cases, right, to support this whole idea of how do we manage employees with medical condition. What does the court say when employees cannot work anymore, right? They are no longer able to work. So the first case on the top, this was a case of MHS Aviation versus Zainul Akmar. So this employee, the company dismissed him. The company terminated him after he was diagnosed with acute inferior and posterior myocardial infarction. Now the court says this, that this termination is unfair. Why? Because the company had not made any inquiries on his illness. And the company issued a notice of termination based on assumption. The company assumed that this illness is permanent. The company assumed. You cannot assume when you terminate an employee. I think he cannot improve. Even like PIP. Can we assume? No, based on the past, I don't think he can improve. So we assume. Cannot assume. Right? You need to go through the process to understand, right? Get a qualified medical, a practitioner to advise you, right? We cannot just, we assume, right? You can't. And then in the second scenario, Gopala Krishna versus Goodyear. So what happened in this case? The judge in this case says this, when we medical bought out, when we remove an employee due to medical condition, right? Sometimes we call it medical bought out, we call it frustration of contract, we call it termination of medical reasons. Okay, let's put this terminology aside, right? Let's not worry so much about terminology. So when we medical bought out an employee, when we remove an employee due to a medical condition, we terminate them, the court says this, the company is expected to be reasonable. You got to act reasonably. Because why? As an organization, we have a social obligation, social consciousness, right? We are supposed to care for the employee. So what should company do? Company should attempt, right? Try your best. See whether you can offer an alternative employment to the employee, even though it may be a lower paying job. Not Arul said it, but in the case of Gopala Krishna versus Goodyear, the court said it, right? Offer them, if you can, please attempt, please try to see if you have a lower paying job, offer them, right? Lower paying job. So let's say now I've got a technician. He job grade 4, salary 4,000 ringgit. His job requires him to, climb the ventilation, the, local exhaust ventilation that's above your, rooftop or ceiling. And he's supposed to go and do some measurement, check the condition, repair, let's say in a manufacturing environment. Now, because he met an accident and now he's got a permanent plate implanted into his leg and he limps, right? He limps. And he cannot climb, what do you call this? He cannot climb, the exhaust. He cannot climb the roof. So that's his condition. But you have a job grade 3 at the warehouse where their job is to record all the, incoming goods, inventory, and what has been dispatched out, right? Whatever that has been, sent out of the factory. So now it's a lower grade, lower job. So what do? You offer to the employee saying that due to your condition, you cannot perform, you can no longer, tak boleh lagi, perform the job of a technician, grade 4, repairing the local exhaust ventilation. So what do? We have this job, it's a lower paying job. Black and white, offer to him. If he says, yes, I would like to take up this job, then you regrade his job and lower his salary to meet the job, right? So that's what you do. If the employee says, no, I don't want, then you have no other option but to frustrate his contract at that time. So sometimes people also ask me this, should I wait for Perkeso? Because Perkeso will take some time. They need to apply and whatnot. So should I wait? So some companies, they wait and wait and wait and wait. It may take 1 year, 2 years. So my advice would be, if I go back to the table here, the flow here, whichever comes to an end in the 12 months, if your process comes to an end in 12 months, he goes. If Perkeso comes in between, he goes out via Perkeso. So do you need to wait for 16 months, 18 months, 24 months? That's your choice. But for me, 12 months, we are done. You have not got Perkeso yet, but we are going to medical board you up. Or we're going to frustrate the contract. So if you want to wait, it's your choice. And what exactly is frustration? Because I mentioned this frustration a couple of times. So frustration, the term frustration, you will not see it under Employment Act. But if you read the Contracts Act 1950, Section 57.2, so all contracts in Malaysia is governed by the Contracts Act. It says this, when a contract, so maybe I just use some layman language. In a contract arrangement, there's two parties, party A, party B, right? Employee, employer. If either party, mana-mana pihak, right, either one of them, if it becomes impossible, if any one of them, they cannot fulfill the contract anymore for reasons beyond their control. Somebody falls sick, right? Beyond his control. Became sick, unwell, cannot work anymore. So beyond their control, then the contract is deemed to have been frustrated. So when either party to a contract, whether it's employee or employer, same goes to employer. If the company the whole factory burned down, I can't give you a job anymore, right? The contract could be deemed to have been frustrated. So this is what we call as frustration of contract. So when does this frustration apply? When something happens and it's not the fault of either party. If an employee falls sick, the employee will not pray to God, God, give me sickness. I don't want to work anymore. Nobody will ask for that, right? Employee becomes ill, not his fault, right? So when something happens through no fault of the other party, not their fault, then the contract may be frustrated. So when does the contract become frustrated? For example, when an employee dies, the employee is not going to come and apply, tell the company, so I nak mati, so I want to resign first. No, right? He passes away, contract gone. You don't need to terminate him. He don't have to resign, and you don't need to terminate him. The contract frustrated. Prolonged illness, right? Becomes, employees, on long sick leave, right? How long do you wait? 6 months, 12 months, 2 years, 4 years, right? Prolonged illness. The illness is so long. Or they may have become incapable to perform their duty due to illness or accident. For example, employees under coma, right? Months, right? Doctors also not able to advise when they'll wake up, right? How long do you wait? So at one point in time, you got to say, okay, I think this is it. We cannot wait any longer. Somebody's got to do the job, right? So that could be one condition. Or the employee was held under police detention or custody for a period that we do not know. So that situation also can occur, and this could be also, the contract could also be frustrated. Or the last scenario is the professional license of an employee, right, gets revoked. So through no fault of their own, that means it is not their fault. If the license got revoked because of misconduct, for example, if your company is into transportation or logistics, you've got lorry driver. Now they need to have a license to drive lorry or a bus, and they were speeding, or they maybe knocked somebody and somebody died. And now when somebody knocks and somebody dies, they charge them for murder. And for some reason he was detained and do not know how long, etc., or the license got revoked. No more driving license for 5 years. How do I employ him? I employ him for driver. Do I need to offer him any other alternative job? Not necessarily, right? So this could be another scenario where the frustration is, frustration may take place. Now, having said all that, if you frustrate a contract, you terminate a contract, or you want to use the term, we medical bought out, etc. Medical bought out we use when there's a medical board. The process goes through a medical board, and the board decides that this person cannot work anymore. That's medical bought out. If your company is going to terminate an employee, but they don't go through a medical board, that shouldn't be medical board, right? So now, can the employee file a case against you for terminating me or frustrating my contract? Answer is yes, they can, right? They can. They can say it's unfair. They can still do it. They can still go to industrial office, file a case for unfair dismissal, and then you can either reconcile, go for a settlement, or let the case go to industrial court and let the court decide whether this was a fair move by the company or not proper. Again, on the other hand, in the case of Garrix versus Nolan, the court says this: the employers cannot be expected to go to unreasonable length. You cannot be waiting forever, right, to accommodate an employee who is not able to carry out his job to the full extent. If he's hired as a lorry driver and he has been on leave for a long period of time, the court also would understand you cannot wait forever, right? So just bear this in mind. And now this is a very interesting one. So I hope all of you are listening. Put your phone aside, right? Listen to this carefully. And I would say 80% of your issues, or maybe more, is here. Malingering. Malingering means what? The employee he's not sick. That means he's quite okay. He's healthy. But he pretended to be sick. He faked his illnesses. It happens, I tell you. He faked his illnesses. Doctor give him an MC and he don't come to work, right? So malingering means he's not unwell. That means he's okay. He's not sick, but he got an MC. Now, of course, you'll probably say, no, I think the doctor don't know what, etc. Now, remember this. There are some illnesses that can be tested. If the employee says, I had high fever yesterday, the doctor can check, put a thermometer and check whether he had a high fever. Or he says that, no, I got urine infection. That can be tested, right? The employee says that, what do you call that? I got high blood pressure. My blood pressure went up, right? Now, all this can be checked. But what if the employee says that, oh, I had a migraine last night, right? I had migraine last night. How? Right? I had migraine last night. Or, ceri-berit. Doctor, semalam I ceri-berit, doctor, 10 kali I pergi tandas. He go to the clinic, let's say he claimed they had diarrhea. Don't know what I ate last night, diarrhea. So morning he wakes up. Actually, what happens is this: alamat, 10 o'clock. If I go to work, I'm sure my boss will scold me. So he go to clinic, don't comb his hair, mandi minyak cak kapak, and I tell the doctor, I say, doctor, semalam, doctors, I went to toilet 10 times, doctor. The doctor look at his condition. He say, your condition looks so bad. I think you better take 1 day off, right? Is the doctor not truthful? Because illnesses like this, how to test? How to test diarrhea? The doctor is not going to tell him, okay, you know what, Janet, why not you stay in the clinic? I want to see how many times you go toilet. Doctor will not do that. Look at the condition, looks terrible. Doctor said, you better take this oral medicine and rest for 1 day. That's what the doctor could do. Or the employee says that, doctor, last night I was having terrible migraine, right? I couldn't wake up. Morning, my head was spinning. I really couldn't wake up. I took 5 Panadol. What do you think doctor can do? Right? And he comes to clinic, he put the plaster here, and then the smell, and then he said, doctor, he cannot sit, cannot stand, etc. Doctor cannot, in that condition, can the doctor say, no, you go back to work? Cannot. The condition is so bad. Right? So, or he said, doctor, I got back pain. I've been having this back issue for the last few months. And, this morning I couldn't get up at all. The moment I tried to get up, my back hurts so painfully. Right? Even now, doctor, I can't even sit. It's hurting my back. What is the doctor going to say? You know what? I'll give you a painkiller. You rest at home today. So is the doctor wrong in this case? So there are scenarios where doctor have to listen to your declaration. Now, today, I think there's about 580 of you all in the call, in the webinar now. I'm sure you're not the hantu, right? You're not the one who always abuse. Now, I'm sure many of you all, you tell me yes or no. Many of you all, when you are not feeling well, right? When you're not feeling well, I want to see the response. When you're not feeling well, I'm quite sure, right? Let me just open up the link. I'm quite sure you would have gone to the clinic. You would have told the doctor, you know what? I'm not feeling well. Etc. Doctor, look at the condition. Doctor, give you MC. Am I right or not? I'm sure you all would have this. So these kind of scenarios do happen. So is it doctor's fault? No. What happened here is employee made a false declaration of his condition, right? Employee made a false declaration on his condition. Not the doctor's fault. So these kind of issues happen. But if an employee submitted fake MC, he modified MC, MC is not correct, you call the clinic says, hey, this MC here, kita tak issue. Right? He changed from 1 day to 2 days. Now that one is, please terminate. Right? Falsifying MCs is termination. Now, if you found out employee was malingering, he's not sick, but pretend to be sick, and is proven, termination. No first warning, verbal warning, etc., termination. But how do you know? That is why if an employee, you see a trend, right? Why is this employee every Monday, every Friday, every, after payday, after public holiday, before public holiday, one time we won't know, right? But you see a trend. Every, the last few public holiday, before the holiday or after holiday, it's on MC, right? When you see a trend, what do? Send him to Dr. John, please. Don't try to save that 200, 300, 400 ringgit. Send him to Dr. John. Tell Dr. John, we would like to assess him. Dr. John may say he's fit. He couldn't produce any evidence. So what do? You limit his clinic first. If it's proven that he was, he malinger, terminate him. So if you go to Facebook, read a couple of cases there. For example, employee was shopping on MC. Employee went holiday, took Facebook and, he put in his Facebook, holidaying on MC. Terminate, please. Right? Playing football. So take note of this. Again, you can't just say, oh, playing football. Evaluate the case, do your investigation. If it's proven true, then terminate him. Right? You want to put him through DI, terminate him. So remember this. If an employee malinger means what? They took sick leave, but they're not sick. They don't want to come to work. To avoid work, they pretend to be sick. They made a false declaration. When they see the doctor, they made a false declaration, right? And tell doctor, I'm not feeling well last night like this. Doctor will, just like y'all, when you're unwell, you just go and see doctor, last night, I'm sure doctor would have said, you know what, rest at home. They try the same trick, but they're not well. Sorry, they are not sick. So cases like this is called malingering. So in the case of Regent Kuala Lumpur versus Gerard, the industrial court says that this employee was caught malingering. So why? He claimed that he was on sick leave, but at the same time on the day, he attended family day. Right? If you're sick, unwell, you should be resting at home, not shopping, not going on a holiday trip, playing football, etc. Right? If you're unwell, shouldn't you be resting at home? So malingering is the biggest concern of all companies. I don't need to ask you, but I think you all would agree. Malingering. So what do you do if employee malinger? Send them for assessment, right? Not the first time. When you see a trend, send for assessment. Limit their clinic, right? I'm not saying that make life difficult for them, but I am also very sure you don't want anybody to abuse medical privileges. If you are sick, rest at home. But if you're not sick, you must come to work. You're being paid for work. So not employee cannot say, oh, you know what, I got 14 days MC. The law give me 14 days. I can take 14 days MC. The law says this. The 14 days MC is when you are genuinely ill. If you really cannot come to work because you're sick, yes, please take MC, please rest at home. But the law did not say that this 14 days is cuti tahunan tambahan. Right? Oh, I don't want to come to work today. I just tell doctor, I'm feeling unwell, etc. Again, so it's not. So you got to tighten up your medical, process. The problem with all of y'all is this. Maybe not all of y'all. Some of y'all is this. You keep complaining employee abuse, but you don't do anything. And then you go around the town how to manage these employees. So starting today, please appoint an OHD. Go and find an OHD doctor or a physician. You find who's the right one. Every time an employee, you see a trend, send for assessment. The doctor may cost you, the doctor may charge you 200, 300, 400 ringgit. I'm not so sure how much, right? Don't try to save that money, because what you're paying for MC is much, much more higher than you do this. Once you start, right, the other employees will know that, oh, you know what? The company is very strict. They check on you. If you have a trend, they will send you for assessment. So the other employees will start to have, I'm not saying that frighten them, but they know that a company is serious about abusers. But today, you don't do anything. We keep crying, whining, complaining, etc. Then we say, oh, employee abuse. Start doing something. And if you look at this case, this was Dunlop industry versus the union versus employee. In 1979, it's an old case, 49 days of medical leave. Then the following year, 32 days. And if you see in a short span of 8 to 9 August, 16 to 23 August, in a short span of 1 month, not even 1 month, about 3 weeks, 7 days MC from different clinics. And what the company did, the company sent him for assessment. So the claimant means the employee who was terminated. He filed a case against the company, is a claimant. So the claimant, when the company sent him for assessment, or her, this employee was certified physically and mentally fit. And there was no any other evidence to explain why his health has gone from bad to worse in the period of August to September. And the court agrees that the company has established the case. That means company was able to prove that the claimant has no serious or long-standing illness to justify his excessive medical leave. So all of you are listening today, if you have this issue, read this case again, right? If you're able to go and find this case, download it, read it. Now, the court agrees that a company had proven its case. The company was able to justify that he did not have any serious or long-standing illness to justify his medical leave. So you see, he's certified physically and mentally fit. And in the case of Klangport, 1994, 35 days. The following year, 47 days. Again, 48. Then the following year, again, 51. So you can see this pattern. So he was subjected to a counseling session. The company put him through a counseling session for his medical history. The company asked him, Janet, why are you taking so many leaves? What happened to you? Of course, the employee will come up with all kinds of excuses, right? You ask the robber, did you steal? He said, no, I didn't steal. So this employee was subjected to a counseling for his medical history because he said that I've got gastric and there was an operation made to my stomach. And so this caused his medical problem. The company, he underwent a compulsory medical test. Again, you see, compulsory medical test. The doctor certified him fit. So I hope you all are seeing this, not just, listening, masuk kiri keluar kanan. He was given counseling. The company put him on a compulsory medical test, and the doctor certified him fit for normal duty. He was given final warning and reminded to change his attitude and improve his performance. Because there was no improvement, he was suspended and later dismissed. Right? Of course, there are some in-between process. I'm sure the company will done, send him for another assessment and whatnot. So what the court says, if an employee is genuinely ill, please rest at home. Go and see doctor, get MC, rest at home. But if they abuse this privilege, that is already a problem. Okay, so this, until this point, is to tell you a couple of points. Let me repeat what is it again. Number one, if an employee is genuinely sick, memang sakit, not bohong, support them, give them whatever support you can give, care for them, whatever, etc., tender loving care, fine. But if you see abuse, you see a trend, please send them for assessment. Limit their clinic, right? And, you know, if they don't improve, they don't, send for another assessment. And if you find that this is keep happening, you got to make a decision. Should you keep him or should you probably start to, start working to remove him? No, it's either this or this. Now, let me ask you this. So I hope all of y'all, you have a copy of this, right? I hope you have a copy. So this is I'm not the publisher. I don't get any commission if you buy this, but please get a copy of this Employment Act Handbook, and it covers all the regulations as well. Now, some of y'all may not know this, so let me just say this. If you look at section 60F, that is on sick leave, it says this, an employee, after examination at the expense of the employer, in other words, at your expense, the employee shall be examined. Whose expense? Company. So can you limit the medical benefits? Or our limit is, we give employee 300 ringgit medical benefit per year. More than 300, no more claim. Based on section 60F, it says this, an employee shall, after examination, that means consultation, at the expense of the employer, at your appointed, you appoint the doctor. So if you do not want the employee to go to different clinic, you fix the clinic, you pay for it, and they shall be examined there. Now, can you limit the annual medical costs? Answer is no. You can limit consultation, but you can limit medication, but you cannot limit consultation. I repeat, you can limit medication, but you cannot limit consultation. Why? Section 60F1 says that an employee shall, after examination is when the doctor check on you, he assess you, assessment. After assessment, at your expenses, you got to pay for it. But section 60F did not say that you must pay for medication. So when they go to clinic, there are two costs: the cost of examination or consultation, the cost of medication. So if you want to limit, you can limit medication, but not consultation. Now, again, please also know this. If you want to limit medication, no problem, but not consultation. And what was my point? I missed one point. Yep. So you can limit medication, you can't limit consultation. Some companies, they even ask the clinic to itemize the bill. So the clinic, right, consultation is how much, medication is how much, so that you know what are they spending. So you can limit, but only medication. So after 300, you can say no more medication, but you still pay for consultation. And can you appoint a doctor and tell the employee, you can only go to Dr. John? You can, because section 60F1A says that by a registered medical practitioner, duly appointed by the employer. So you appoint the doctor, not mana-mana doctor, clinic mana-mana, here, there, etc. No. You appoint the doctor, you pay for it. Employee must go there. If an employee go and get an MC from another clinic, you can choose not to accept. You can consider them to be absent on the day, right? However, if, let's say, the medical practitioner that you have appointed, right, he cannot treat a particular illness. Maybe he's just a normal GP, but the employee has got some other illness. He cannot manage, the doctor is not qualified. Or the doctor that he appointed is not within where the employee is. He may have traveled to Moa for a holiday and he falls sick during the holiday. Now, you expect him to come back to PGA to see Dr. John? No. So because the doctor they appointed, he's far away. So for scenarios like this, the doctor they appointed, they are far away, they are in different location, or the illnesses that they have, that they have contracted, cannot be treated by this doctor because he's not an expert in it. So for this reason, the employee can be examined by other registered medical practitioner or a medical officer. So only when your appointed doctor, he's not within a reachable distance or time, distance or time, or the nature of illness requires the employee to go and see another doctor. For this scenario, they can see others. So question, can the company limit medical benefits? Answer is, they can limit medication, but cannot limit consultation. So you can ask the clinic to itemize the bill if you want to. Can a company confine employee to selected panel clinic? Yes, because Section 60F1A says that by a registered medical practitioner appointed by you, appointed by the company. Unless the employee is at a different location, or it's going to take him a long time to go to your appointed panel, or employee sakit but cannot be treated by your doctor, then yes, go to another doctor, right? So this is what Section 65F1 says. So I hope, I've clarified on this as well. So question, how do you spot a case of an employee abusing medical leave? So when you see a trend, send them for assessment. Simple as that. One time, maybe it's too fast, too quick. We do not know. Maybe it's genuinely ill. But if, let's say, you see, every Friday, not every Friday, quite frequently on Fridays, quite frequently on Mondays, maybe after payroll or after public holiday, before public holiday, and you see this like a pattern, a trend, send for assessment, right? So what can you do to prevent abuses? Simple. When you see a trend, when you suspected something, send for assessment. Now, I'm sure all of you all would believe this. Yesterday, the employee looked perfectly fine. You see him in the office, laughing, can go for lunch, chit-chat, borak-borak, here can, etc. Today on MC. Oh, doctor, I'm not feeling well today. Tomorrow, come back to work, back to square one. Okay, perfectly fine. Now, let me ask you all this. What kind of illnesses is that? Yesterday was perfectly okay. I mean, let's say Monday was perfectly okay. No signs of illnesses. If they are coughing, right? I'm sure you can hear them coughing. If the flu is starting to develop, I'm sure they have the handkerchief. They'll be blowing the nose, right? But nothing. Or if they're having migraine or whatever, sometimes you can see the symptoms. But in this case, there was no symptoms at all. But suddenly unwell. MC. Tomorrow come back, perfectly fine. I can tell you, I could be wrong. You may say that, I'm very inhumane, but a majority of these cases, not genuine. A majority of them. I mean, come on, I am also a human being. I also fall sick, right? You also have fallen sick. But why is that suddenly somebody can fall sick? Okay, sick, tomorrow okay. So to me, when you see this happening quite frequent, and you don't see signs, ask the employee, hey, Janet, we noticed, you strike a conversation. Hey, Janet, we've been noticing that, in your last, MCs for the last 5 times, in the last 3 months, we noticed that whenever you go on MC, you were perfectly okay the previous day. You were perfectly okay when you come back to work. So what really is your issue? Now, anyone here, are you trying to tell me if you do this, employee is going to, walk out of the job? Or you know what? I'm going to walk out, I'm going to file a case at labor or IR. It's unfair to me. You think the employee can do that? Anyone? Just because, you ask them this, hey, Janet, what happened to you? We noticed that the last 5 MCs that you had over the last 3 months, the day before MC, you look fine. The day you come back after MC, you look fine. What exactly is the issue? Because clinic will not write the issue in the MC. Some will write, some will not write. I want to know. As per the company policy, we would like to know. Janet cannot say, it's none of your business. 14 days MC, my rights. Hak saya, you tak boleh tanya. No such thing. As a company, if you find there's an abuse, please take action. If you don't take action, then please be prepared to keep on paying and paying and paying. Okay, it doesn't matter whether the staff visited clinic kesihatan or panel clinic, polyclinic, some big time specialist center, big time, doesn't matter where he visited. If you suspect there's an abuse, please send them for assessment. Okay, so now, how do we manage employees with medical health conditions? I will answer this in the Q&A, right? If you have an employee, it happens, right? An employee over a period of time, they become ill, mentally ill, and cannot work. What do? Let me answer this at the tail end of the presentation. So for all of y'all, I mean, if you really want to, improve your, management of medical issues, etc., there is a policy, sample policy that we have shared in the forum. It is called Employee Health and Medical Leave Policy. I can tell you it's a very tight policy. When I say tight means this policy do not give employee room to maneuver around, right? But any one of y'all, if you're coming from, I'm just going to joke a little bit. If you're coming from a La Land company, La Land bosses, La Land mindset, oh no, we must treat employees fair, equal, we must care for them, etc., then follow whatever you do today. But if you're serious about preventing abuse, please read this policy. It's airtight. Airtight meaning nobody can abuse. So please read this policy and see whether it makes sense, whether you're going to follow. So, and then there's also a sample assessment form. When you send the employee for assessment, get the doctor to fill up this form, especially if an employee is having medical issue, and you know that chances of recovery is very slim. Remember the funnel I shared? So you can use this form and ask your panel doctor to fill up the form after examining them. So these two documents is available in the forum. So later part, when you get these slides, you can click on this link and please read it. So there's a case that I would like you to read. For those of you all, if you want to read, you want to improve your understanding, you want to know what the court says, this is quite a recent case, I think it was early this year. Read this case, and then you see for yourself what are the what does the court want to see, right? What is the expectation on the company, right? Read this. For those of you all, if you really want to read, improve, this is one case that you can read. In Facebook, we have discussed many cases as well. So this is just one of the cases I want to highlight to you. Okay, now this is a new slide just put in today. So there was someone who asked today, if an employee has an existing medical condition, right? If you don't ask them to declare, they will not declare. And once they report to work, if you find that they are having some medical condition, it might be too late because you did not ask for declaration. So some company, the declaration, very chinchai, one simple sentence, do you have any medical issues? Right? People will say no, because you are not specific. What exactly are you referring to? Long-term illness, long-term medication, or something that I will be on medical leave for a period of time, etc. So please be specific when you ask question, when you ask them to declare. So this is one sample clause you can do. It's a bit long, right? I'd rather take a careful approach than taking a shortcut approach and later part struggling to manage the issue, right? So again, now, I know I may sound a bit inhumane, right? Some of you may say, you know what, this guy is very inhumane, he don't have the moral empathy, etc. But we are running a business, like it or not. I'm also running a business. So now, if you want to support an employee, the employee says that, okay, I got some medical condition, right? If you have the capability to manage this person, you have all the support system, right? You may have an in-house doctor, whatever, etc., insurance, health leave, and whatever, etc., PIL. If you have the support system, you have the capability, you have the capacity, right? If the employee goes on long sick leave, company is still run, no issues, we can manage, etc. If you are able to do all this, and let's say if the employee one fine day, if they cannot work anymore, you're able to board them out or terminate their contract, frustrate it, and pay them a termination benefit, or you can offer them MSS. If you can do all of this, go ahead, no problem, right? I will respect you guys because you are giving them a chance, right? Go ahead and do it. But if you don't have the capability, if you don't have the capacity, if you are not able to pay them money, MSS later, you know what, this employee cannot work, I think we should just give them a package, let them go. Or if you terminate them, you got to pay termination benefit. Oh, it's so expensive, we cannot, etc. And if this employee go on long sick leave, your company is going to struggle. If the answer is no, 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 then you got to ask yourself, should you hire this person? I'm just being very practical, very pragmatic. No point on first day, all excited. No, it's okay. We got to show compassion, empathy, etc. Yeah, we let's think. Then later part you struggle. So how come you were such a nice guy, such a nice company today, you become a devil tomorrow? So please see whether you are able to support. When you go, those of you all, if you go on holiday, right? What does the air stewardess or air steward will say when they do a safety demo? Anybody can answer this question. You will get, my colleague Yon will courier one book for you. This is an employment act. It's not much, it's 30 ringgit. What will the air steward or air stewardess say in one of their safety message, which relates to this topic? The first one to answer, you will get this copy. We'll courier to you wherever you are, except I hope you're in Peninsula Malaysia, so that we don't have to pay so much of courier. So what do you think the air steward and air stewardess say in their safety briefing, which you can tie to this? Anyone? You're like going holiday, right? Okay, who said that? Okay, Eileen, later part you get in touch with Yon, send her your house address, your house or your office address and your phone number. We'll courier this book to you. Yes, you're right. The air steward or the air stewardess will say that put on your mask first before you help others, right? So can we say the air stewardess is very inhumane? How come? Shouldn't you help others first? You should help the employee first. Help the passenger first. The neighbor sitting next to you, help them first. The air stewardess will say that put your mask on first before you help others. So I hope you got my message. Okay, so we still have a bit of time. I just need about 5 to 10 minutes. This is a small bonus topic. Some of you all may already, you may have already attended a class and learned this, or some of you all may be hearing for the very first time. Maternity protection. So Eileen, please get in touch with Yon. Send her your office address and your phone number. We'll courier this book to you. Okay, now this is just an additional info for those of you all, if you need to know. All your questions, after this, I'll answer all your questions. Now, to qualify for to qualify for maternity allowance, there's 2 conditions employer must fulfill. One, they must have, they must have worked for you for 90 days in the last, okay, let me just repeat again. Now, if an employee is pregnant, they deliver a child, they are entitled to minimum. You can give more, but minimum 90 days of maternity allowance and a maternity leave, and up to their first 5 living child. That means child number 1, 2, 3, 4, 5, they can get maternity allowance. Child number 6, they can go on leave, but no allowance. Some of you may call it as unpaid maternity, right? No allowance. Now, in order for them to qualify for maternity allowance, right, they must have worked for you for 90 days in the last 9 months, and they must have worked for you for any time in the last 4 months, right? Any time. So remember this, 90 days in the last 9 months, and any time, at least 1 day in the last 4 months. So these 2 conditions, both, you can see the word "and", both conditions must be met. So 90 days in the total 90 days in the last 9 months, and any time, at least 1 day in the last 4 months. So these 2 conditions must be met. So let me give you a small trivia, right? So you can answer in the group whether it's scenario 1 is yes, 2, 3. So just for the ease of understanding, just for the ease of discussion, every month is 30 days, right? So that is easy. No need to know whether 31, 30, 28, 29. Every month is 30. So in scenario 1, did the employee work 90 days? Anyone? Yes, no? Did the employee work 90 days in the first scenario? Yes. 30, 60, 90. Yes. Did he or did she work at least one day in the last 4 months? Also yes, because they work in month number 7, month number 8, month number 9. Scenario 2, did they work? Why is it not showing the slides? The scenario table. Okay. So now in scenario number 2, did they work 90 days? Yes, they work all throughout. Did they work at least one day in the last 4 months? Yes, they also work all throughout. Even though they end their employment, they have already qualified for maternity allowance. Scenario number 3, did they work 90 days in the last 9 months? Yes. You can see on month number 6, they work, month number 3, 4, 5, 6, total is 120 days in the last 9 months. So yes. Did they work anytime in the last 4 months? Also yes, because in month number 6, they work. So at least one day, yes, in month number 6. So scenario 3 qualified. What about scenario number 4? Did they work 90 days in the last 9 months? Yes, they work almost about 5 months. Did they work any time in the last 4 months? Answer is no, because last 4 months, they did not work. Even, they've stopped work, they did not work last 4 months. So answer is yes for scenario 4. Scenario 5, very similar scenario 4, but you can see, did they work 90 days? Yes. Did they work anytime in the last 4 months? Also yes, because in month number 6, they worked for a few days. So scenario 6, even though she has stopped working, this employee has already qualified for maternity allowance. So you got to pay them. Now, scenario number 6, did they work, right? Did they work 90 days in the last 9 months? Yes, 30, 60, and later part another 30, so 90. So 90 days, yes. Did they work any time in the last 4 months? In the month number 9, they work the whole month. So answer is yes. So it's yes and yes. So they qualify. Scenario number 7, did they work 90 days in the last 9 months? Yes. You can see total 30, 60, 90. Did they work any time in the last 4 months? Yes. Month number 6, they work. They did not work 7, they did not work 8, they did not work 9. But month number 6, they work the whole month. So at least one day, yes. So all the scenarios, they qualify except scenario number 4. Because scenario number 4, the first condition fulfilled, 90 days. But the second condition was not fulfilled. Therefore, they are not entitled to maternity allowance. Typo there. Actually, it's only maternity allowance. Leave, they still got to go, but they're not paid. Okay, I'm going to the next slide. A couple of questions. If you read Employment Act, you read the definitions, you'll get all this. An employee must complete 22 weeks of pregnancy before they can, they must complete 22 weeks of pregnancy, whether the child, after 22 weeks, whether she delivers a child is alive, dead, etc. As long as they complete 22 weeks of pregnancy, they are entitled for maternity allowance and maternity leave. Now, they must at least inform the company 4 months prior to their confinement. If they don't, then they may not be entitled for maternity payment. If the child, as I said, after 22 weeks, she delivers a child, whether the child is alive or the child passed away, she is still entitled. And is there a difference between maternity leave and maternity allowance? So why do I say maternity allowance? Are we trying to say that when they go on confinement, they get basic salary plus maternity allowance, they only get one payment? When we say salary, wages is paid when you do your work, for work done. So here they're not working, so no wages. But the law says you got to give an allowance which is of the same value, right? Foreign female workers, let's say if it's a female worker from Indonesia, they become pregnant, they deliver a child, are they entitled? Anyone? A foreign female worker, this is a white color slide, right? Yep. A foreign female worker, if they, deliver a child, are they entitled to maternity allowance and maternity leave? Yes or no? A foreign female worker. Answer is yes, because Employment Act covers both local and foreigners. What happens if the female employee is not married, but she delivers a child? Is she entitled? Answer is also yes, because the law did not say, the act did not say must be married. It just says that a female employee shall be entitled. So you don't go put in your policy that must be married, right? Your policy will be null and void. So the law says that as long as they deliver a child, they're entitled to. But for paternity, if you recall, for paternity leave, the law says that a married male employee. So for paternity, the male employee must be married. But for maternity, the law did not say must be married. Okay, so I'm done with the presentation. I'm going to answer your questions. But just before I go to the Q&A, a couple of advertisement, a couple of sharing, a couple of advertisement from us. So these are some of our upcoming trainings. I'm showing you the training slide, right? So these are some of our upcoming training, and so you can see that we have a domestic inquiry training coming up. There's a PIP training and grievance management. So one is on Zoom, the other two is live. We are doing it in Sarawak as well. So for those of you all, if you're dialing in from Sarawak, please be fast. I think now you all heard, right? HRDF says that you must apply for your grant 14 days before the training date. So don't wait till last moment, put it on a, not so urgent, etc. The moment you want to go for training, please quickly apply for your grant, because you must apply for grant 14 days before training. So these are the trainings that we have. Domestic inquiry in Sarawak, 15, 16 June, and in PJ, 22nd, 23rd June. 16 July will be managing PIP, it's a Zoom online. And on 19 and 20 is managing grievance, right? This will be PJ, our academy as well. And for those of you all, if you want to learn more on medical process, this is what I presented today is one chapter from the masterclass that we do. So in the masterclass is a 2-day power pack masterclass. I'm sure some of you would have joined. Today, somebody in one of the groups says that they don't know how to manage employees with medical condition, mental health issues, and so much so that they became a mental managing this. After the masterclass, they managed to de-mentalize themselves, right? So now, no hard offense, no hard feelings, etc. My point is, if an employee is not feeling well, you must know how to support them, what to do for them, and how to manage them if you cannot support them anymore, right? So that you don't fall into issues. By the way, just to let you all know, if you do not know, if an employee is terminated due to medical condition, you need to pay termination benefit, right? It's provided for. So these 2 days masterclass series, we are doing it in Selangor, in PJ, Sarawak, Penang, and Sabah. It's not cheap. As I said, you learn lots of things, how to make things easy, how to make things fast, how do you simplify a process, how do you prevent issues from happening, how do you, establish your rules, your, termination process, PIP, etc. So for those of you all, if you're interested to learn more, please attend. Now, everybody should attend this because we also cover a lot of strategies, HR breakthrough. For example, how do we save money? How do we reduce medical costs? How do we reduce, wastages? How do we reduce this? Lots of, learnings. How do I carry out misconduct process in 30 minutes compared to 2 weeks that you're doing today, or 5 days, or 1 month? How do I do it in 30 minutes? So all this will be covered. Not much of seats left, especially for the one in PJ. So if you got to be fast if you want to sign up. And my last slide is, 2 more slides. Metropolitan College is owned by HR Forum. We have just acquired this college and we have gone live. So we do have diploma in hotel management, diploma in business management, diploma in human resource management. Now this is tailor-made especially for working adults, not for school leavers after high school, but for working adults. It's online through LMS. You can log in, dial in, during your free time, do it. 100% assignment based. We've got 3 schemes. You can study first and pay later, or pay as you go, or you can pay upfront much way cheaper. Now you can share this to employees. If you want to help your employees to improve their welfare, you want to help them to improve their career, etc., get them to complete their diploma if they don't have one. So if you're interested, please email metro.edu.my. One of our colleagues will be more than happy to give you info on this. And these are some of the certification programs that you can do. We have got certification programs for payroll, for business partner, for TNA, for those of you all, if you're in L&D, if you're a competency manager, if you're a business partner and whatnot, so, or even industrial relations practitioner, these are all the programs, all are claimable by HRDF, it's all modular. And those of you all, this is an offer for June month onwards. Any one of you all, if you join any of this program, you will also get the SHRM global membership, not certification from SHRM, not the CP, that one you must go through a class and pay a lot of money. This is a membership that we purchase for you, where you have access to resources and lessons provided by SHRM. So this is given to all those who participate in the certification program. So if you're interested, please write into Sophie as well. Okay, so let me pick up your Q&A. So we still have got 15 minutes. That's quite long. So let me pick up your Q&A. I may not pick up everything, but let me pick up some of the very important ones. Those that I feel good and a good question that you have asked. If it's basic question, I'll probably skip. I'll come back to it if there's time. Okay, so let me go from the bottom. MCOP Berhad. Grant approval must be obtained 14 days before training. Yes, you got to apply for training grant. This is a new circular. We have emailed all of y'all. I'm sure you have also read it, here and there. If you want to go for any training, whether it's in-house training or public training, HRDF now says that you must apply for this training 14 days before the training program. So if the training is on 16th of June, you must get the approval, not just apply. You must apply before. The approval must be in your hand, at least latest by 2nd June. So 2nd June to 16 is 14 days. So you cannot say, okay, I submitted on 1st June. Should I submit? Okay, no. The approval must be obtained. It's not submission date, but approval date. So the grant approval must be obtained 14 days before the training program, as per HRDF's latest circular. Okay, let me go to the question answer. Can the employer reject MC from non-panel clinic? Yes, you can, provided you're paying for it, right? If you're paying for it, yes, you can. But if you're not paying for the cost of medication, you cannot insist the employee to go to the doctor chosen by you, because the doctor that you choose may cost 60 ringgit or 80 ringgit if I go. But you're not paying, I'd rather go to Klinik Kesihatan and pay 1 ringgit. So if you are paying, you appoint the doctor, you are paying for it. Okay. Okay, Alicia, your question is too long. I don't know whether I got time to read and answer, but let me go to all the shorter questions first. Okay, now, how should cases involving severe menstrual cramps, that means period cramp, to be viewed in terms of MC trend? For example, if a female employee takes 1 to 2 days MC almost every month due to bad menstrual cramp, would this be considered a concerning MC pattern, even though the reason is consistent and medically related? See, again, we do not know, right? You and I, we are not medical doctors. Maybe it's true, maybe it's not true, right? Because not all employees would have this concern or this issue. Some would have it, some would not have it, right? So to me, when you see a trend, send them to Dr. John. Let it be Dr. John's problem to advise you, right? That'll be the safest way. Because if you now tell the employer, how come you're on sick leave? Employees, I'm having this cramp, whatever, etc. It may happen. We know some employees, they do struggle with this. So if you suspect something is not right, and you want a second opinion, you want somebody to advise you, send to Dr. John. Pay for it, send Dr. John. If Dr. John says, yes, this employee is suffering from this, then we accept it, right? So to answer this question, it is best to send them for Dr. John. When I say Dr. John means your appointed doctor, right? Let your appointed doctor assess their situation and advise you, right? That'll be the safest way. Okay, can explain the new scheme for Perkeso 24-hour protection. Okay, the Lindung 24, as far as I know, is only paid by employer, not company. For companies, you're going to pay the same rates that you've been paying all this while. The employee would have to pay extra 0.5, for this new scheme, right? Only for employees, not company. Yeah. So now you have to deduct from the employee's salary this 0.5 and submit to LHDN. Submit to Perkeso. There's a sample memo that we have shared in the forum. So if you have not, because it starts in June, so June wages and next month deduction. So for those of you all, if you have not yet started, please get the memo that we have shared in the forum, modify it if you want to, quickly publish to employee. The sample memo is in the forum as well. Okay, let me just give me a second. Let me just scroll upwards. Alicia, your question is super long. It's a bit hard to answer. Yep, say again. Okay, yep, I'm going to scroll up. Just give me a second. I can't see this. Would you be able to show here? Yep. Okay, just give me a minute. My colleague will help me to point out the question. Okay, so Fiona, I don't think I'll be able to answer constructive dismissal because it's not related to this. But I would encourage you to ask this in our Facebook group or our WhatsApp group. I'm sure we'll be more than happy to answer. Okay, the questions are up. So let me just go through the questions. So just give me a second. You can start. Yeah, okay, maybe we start from here. Okay. So Kathleen, if an employee has a record of frequent MCs due to mental illness, which caused them to have lapses in their MCs, is not rather than it being continuous, the diagnosis allows the employee to be fit at one moment and not fit the other moment. How do we handle this? So now this is also quite common. An employee is having mental health issues. Sometimes they're okay, sometimes they're not okay. So how do we handle this? Now, it's going to be a very difficult question to answer. So I must give you this disclaimer. It's going to be a difficult question for you to answer. Can't give you a straight answer. Some of you all may disagree with my response. You may think that, oh, this is very inhumane, etc. But, as I said, it's going to be a difficult answer. Some of you all may find my answer a little bit difficult to digest. Now, earlier on, I made this statement. When you want to hire somebody, right, you got to assess their condition first. So if the employee has got a medical condition, and you've done the declaration, they've declared they got medical condition, if you are able to manage them, you have the support system to manage them, you have the capacity to manage them, if they really become unwell, you can still support them. And end of the day, if they still cannot, you can probably give them MSS, tell them, you know what, things are not working out, why not you take this and go? If you can do all of this, take them in. But if you don't have the support system, you don't have the capacity, you don't have the capability, your company is so tight, so lean, you're running on, extreme tight budget. If one employee is on sick leave, you start to struggle, then you got to ask yourself, are you able to, give them a job, right? That's first part that you do. Now, when you hire an employee, you do not know their condition, right? You don't know the condition. They may look perfectly okay, but after some time, after maybe a couple of years, they go through some, situation where they start to have depression and they start to, have this mental illness, etc. What do you do? So there's two parts to it. Phase one, support them, right? Talk to them, see what can be done. If you can make some adjustment, do it. Whatever that you can do, send them for assessment if you want. Let's say the employee has been, on and off issue, and then they say, I got a psychiatric report, etc. Send them to your doctor for your doctors to assess them. Now, and support them. But if come to a point, right, phase two, you got to start caring for the company. If you can continuously care for them, you have the support system, the financial capability, you have additional headcount, you can manage them, even though the guy is on sick leave, long sick leave, you can manage them, continue. But if you can't, you got to, say that, okay, I think this is it. We cannot manage this employee anymore. Then like I said, at the earliest stage itself, put them through what I call as medical process management. At the earliest stage, the moment put them through the process. Because, like it or not, I'm not a medical expert, but what I understand, what I know, once they've gone into a certain stage, there is no U-turn back, right? Medication can help them to maintain their status or their situation for a period of time. But as time goes by, things may become worse, right? Maybe not all scenarios, maybe in some scenario. So part one, you care for the company. Care for the employee, part one. But after some time, when you know things are not improving and their condition is affecting others, other employees are fearful to sit next to the person and whatever, etc., you got to start caring for the company. So some of the advice I've given to to some companies who call me up, I tell them this: call the next of kin, right? The next of kin. Don't see again to HR. Don't take the burden on your head, right? What to do, etc. There's a next of kin. Call their next of kin. If the next of kin is the father, the mother, or the wife, or the husband, call them. After all, they're next of kin. Call them and say that, hey, you know what? Your son, your husband, your wife, whatever, etc., is having these issues. Company is not able to support them, right? We have been managing them for the last 6 months. We want you to be involved in the process, right? What is his condition? What can we do? So let me tell you what are the things that company have done. So one company invited the next of kin, discussed with them, and they agreed on a separation package. One company gave 12 months pay, the family accepted, they took the package, they went. Another company offered 2-year pay. They say, you know what? We are kasihan for him, but we cannot cope him. See, kasihan, but he cannot cope. You got to do something, right? So one company gave 2 years pay to the employee, right? As a separation package, the family took it and they left. So it's up to you. One company called me up, I've got this issue, what do I do? So I told them this: it is best to call the next of kin, right? Talk to them, see what can be done, right? One of the options that you can put on the table is MSS, right? Because the condition, it cannot work, we offer a separation package. So this company said, no, my boss said cannot, we don't want, etc. We want to give him a chance, etc. Now, I can tell you, this company called me back after 12 months. Hey, we still got this problem, how? Right? So certain things we already know ahead of time. So to answer any questions on mental health issues, part one or phase one, help the employee, do whatever you can, support them, and so that they can continue working. But when it comes to a point where you cannot manage them anymore, now you got to start caring for the company. Because why? There's one scenario, this employee was not, mentally unwell. He was carrying knife in the bag, right? He was carrying knife in the bag. And so the HR got together, they opened up the bag when the employee was away because somebody alerted them that he's carrying something in his bag. So you also do not want situations like this to happen. So at one point in time, you got to make a decision. So my advice to company is this: start your monitoring process from the very early beginning, right? And for the initial part, remember the medical process I said is 1 year now, right? The medical process 1 year. So the moment the employee says that, or the moment the employee is having medical health conditions, put them through the process. It takes 1 month, 1 year. At the end of 1 year, if the condition is stable, no problem, employee is able to work, company is not affected, etc., continue monitoring. Continue monitoring. But if after 1 year, the employee's condition become bad, from bad to worse, cannot work, and etc., then you got to make a decision. Should I frustrate his contract, right? Now, again, I would like to remind all the HR professionals, right, all the HR folks, remember, do not struggle alone. Don't struggle alone, right? Call the next of kin. I hope all of y'all, when you hire an employee, I'm sure you ask them to declare, certain things and ask them who's the next of kin. In case of emergency contact, next of kin, who is it? Please ask. If you have not done so, today you do not know who's the next of kin, please send a form out to all employees to update their employees' personal particulars. There is a form in the forum. Download the form. There's also a sample memo, right? The memo and the form, email to all your employees, ask them to fill up and give it back to you. Who's your wife? Who's your kid? Who's your next of kin? So when there's a condition that happened to them, if they struggle from certain issues, especially mental health issues, call the next of kin. So sometimes I hear advice from people, no, you got to get a psychiatrist, call befriender. You can do all that. But alert the family, call them, discuss what we can do together. Most HR don't do this. They take put a burden on their head, and then they become kelam kabut. So call the next of kin, do whatever you want to do. But call the next of kin, make sure they know that you know, and see what can be done together. Okay, next question. I hope, it's not an easy question answer, and some of you may not accept what I said, but, when you run a business, we cannot be like, clueless. Okay, recently several employees have applied for AL, annual leave, to attend medical checkup. After the appointment, they receive MC and request to convert AL to MC. Is this allowed? Answer is no. So if you are on annual leave today and you're perfectly well, you just want to go and get assessment, then why do you apply annual leave? Something's wrong, right? So Ruby, I have to put the blame on you. Why did the company not make all these things very clear? Right? You got to make things very clear. If you are on sick leave, go to the clinic or go to the hospital, get the doctor to check on you. And if the doctor feels that today's condition is bad, get MC. But if you apply annual leave and then you convert to sick leave, how is that so? You mean you were perfectly okay in the morning and then in the afternoon you became unwell? Cannot be. Now we know that this MC is, maybe they're not sick. So answer is no. But Ruby, please make your company policy clear on this. The problem is you don't make your policy clear. So specify in your policy, any employee who wants to convert annual leave into sick leave, it is not allowed. Right? Unless if it's genuine. Right? So if the employee want to do this, Ruby, you know what I will do? I'll say, you know what? Go and get Dr. John to endorse this. If Dr. John endorses this, I will accept it. Right? Because again, I'm not in the situation to decide whether how come morning you're okay. So let Dr. John do it. So you're kind of making it a little bit more difficult to them. But what I can see here is a pattern of employees not feeling well. Right? Sorry, they're actually okay. They may want to just go for follow-up check, etc. But you don't know what drama they do in front of doctor. You do not know. They may tell the doctor, today, morning I couldn't get up. I was not feeling well. So I couldn't go to work. The doctor said, yeah, okay, I give you MC. So you do not know what they're declaring to the doctor. Right? But to me, answer is no. Okay, next. Okay. Now, yeah, construct dismissal, no. Not the right topic today. No, upstairs, up. The long one. Okay. Okay, yeah, maybe let me answer this. So there's a question, not medical, not exactly our topic today, but employee under probation, he's found to be colorblind. I think colorblind, you cannot see some colors. And the job requires identifying red, yellow, green indicators on monitoring screens. How do we deal with it? So now I would say, this is where companies are not doing things right. Now, if you know that, I come from manufacturing as well, and we do a colorblind test during interview. If you know they're going to go into the area where it requires detecting wires, you should have done a colorblind test during the, interview itself. So you missed that part, now you struggle. So how? So to me, don't bypass this lah, right? Get the basics done, right? You're supposed to do a colorblind test, right? Before you hire them. If they need to do certain things, assess them. Why are we not assessing them? Colorblind you can do within, I remember there's a couple of cards. We asked them, okay, read this number. The number is, it's hidden within some colors, right? If they can read, means they're okay. So you should have done that. You bypass the process, today you struggle. So now what you need to do is, the probation period, if the person really cannot, right, you have no choice but to end their probation. But before you do that, my advice, Kiruba, is see whether there's any, you already brought him in. It's your fault. And if you don't tell him he's colorblind, it's not his fault. I mean, if you don't tell him that this job requires you to assess colors, it's your fault, right? So what I would do, again, this may not be a good concrete answer. What I will do, I will see if there's any other job I can move him to. Maybe there's another job that he can do that don't require, colorblind. Being colorblind is okay. If you have a job, offer that to him if he meets his job grade, whatever, etc. But if don't have, then you may have to put him in his contract. A safer way is to see whether you both can discuss, work out a package, and end the contract. Right? That's the best you can do. But again, I want to remind ladies and gentlemen, please don't bypass the processes. Right? If you bypass the process, you will have a headache later. Okay, next. Yeah, I think there's a. Okay, no, next one down. Okay. Okay, now, can the employer reject the MC if they believe the employee is not sick and the MC was issued only for medical review? Of course, yes. Now, you see, but again, you do not know. You were not there. The employer give you MC. You don't know whether he's unwell or not well, right? You don't know what he told the doctor. He may have made a false declaration. So I will not want to say that the doctor did not do things right. But the employee may have made a false declaration, right? As I said just now, this employee saw the doctor, put on a nice drama, can win Grammy Award or Academy Award. Good actor. They put on drama today, doctor, I'm not feeling well, how, etc. So, and the doctor gave him MC, right? So to me, I would say this, one incident, I don't think we have something concrete. But when you see a trend, right? When you see a trend, take action on them, send them for assessment, right? You won't know whether it's a medical review. Employer may not tell you, right? But if you found out, let's say the employer was, honest enough to tell you, you know what? I went to see the doctor and the doctor did a medical review but gave me MC, right? So what can you do? If you want to give them a chance, give them a short, advice. This is not acceptable, right? Or you give them a show cause letter and ask them to explain why did you submit MC when you were not sick, you just went for a mere review, right? Ask them to explain. And if the explanation given is not strong, give them a warning letter. But I would advise you to route through your clinic, your Dr. John, for example, route through Dr. John and issue a warning letter. That way you're safe. Okay, yep. So what if the employee gotten 3 days MC due to gastric trio anxiety, followed by 2 days due to stress-induced anxiety? On the second day, we have requested to go to Dr. John, but employee reluctant and continue. Very simple, Andrea Chi. Number one, you must spell out in your policy that employee must go for compulsory medical screening or medical assessment when the company instruct to do so. If they don't, it's insubordination. That's number one. So please put that into your policy. Second, remember section 60F says that you can confine the clinic. So if your employee goes to a clinic that is not appointed by you, then don't accept the MC, consider it absent, right? So sometimes you see, I mean, may not be very proper for me to say it, live with 680 of you listening, but if an employee abuses, etc., you got to make it hard for them. I'm not saying that you penalize them, but because you give them easy peasy, relax, free flow, etc., they will find how to abuse it. But if your things are tight, abuse will become less, right? So that's my answer to Andrea. Okay, now this is an interesting one. Yeah, Xuan. A probationer takes frequent MCs. Probationer takes frequent MCs, and the company decided to terminate him without first obtaining a proper medical assessment, even though HR has already advised him. Now, first and foremost, Xuan, now, based on past cases, what the court always tells us, if you read cases, if it's a performance-related issue, you have to wait for the probation to expire first. You cannot terminate prior. You must wait for probation to expire. Now, if the employee, right, has got medical issue, MC here, MC there, etc., don't terminate him yet. At the end of the probation period, if the employee's performance, efficiency, aptitude, attitude, all got issues, you've done your monthly assessment. I remember, I always advise everyone, do monthly assessment. Plus, he has got series of MCs. You couple all these together, use that as a basis, and don't confirm him. It's easy, right? Don't terminate him yet. Let the probation expire. And then you tell the employee, you've got issues with your attendance, your performance, attitude, aptitude, and also your attendance because MC and whatnot, and use that entire thing as a basis to not confirm him. That's it. Okay. Okay, maybe one last question. Okay, now this is interesting. Got one sharing regarding PDPA. They can no longer state their medical reason on MC due to patient confidentiality. Even calling the clinic can also be accounted data breach. How can we tackle this? We cannot know workers' condition. So now, Sing Yi, let me ask you this. Have you asked the employee to give you permission upfront that these are the things that they should allow you? For example, when they report to work, or maybe even before they report to work, right? Report to work too late already. When they apply for a job, ask them to give you consent that company can do a background screening. Company can also, all the things that you want company to have the privilege. Ask them to declare all this. They've given you permission. If they've given you permission and whatever data you obtain, I'm not putting a World Wide Web. I'm not being a CNN. Hey, you know what, ladies and gentlemen, this person, no. I'm getting this info only for company's purpose. So tell me where got PDP. So tell me what is PDPA. Sometimes I tell you this. Some people, sometimes, I don't know what, they over-exaggerate PDPA, etc. Now, like that, don't run business. Close shop, ask your boss to stay at home, right? So you got to know what PDPA says can, what PDPA says cannot. And now if I would ask you early, I may ask you declaration or permission. So tell me where you've gone wrong. And whatever info given, I'm not sharing to anybody else. It's all within the company, right? So what PDP are we talking about? Can we reject 5 days MC? If the employee is genuinely ill, the doctor gives the MC 5 days, and the employee is genuinely ill, how? But if you see a trend, every now and then got 4 days MC, 5 days MC, 4 days MC, that's a trend. Trend assessment, please. Right? But one time, let's give them the benefit of the doubt. Okay. So any other question? Yep. Okay. Okay. There's 2 more. Okay. Now, for those of you all, if you need to go, if you have time up, work is up, you need to go, please go. But for the rest, maybe you can stay back for a few more minutes. Let me answer a few more questions. So for the rest, thank you for listening. We hope that the webinar has been useful to you. Download the policy, the assessment form, and I hope that you have now better idea how to manage when you have an employee with medical condition. So see you in another the next webinar. We have one more webinar in 2 weeks' time. So see you in the webinar, and the rest, please stay back if you want to. So staff stroke because hypertension, di bedah bahagian kepala, MC 76 hari, 73 days MC, 60 days hospitalization done, finish. He still cannot recover after 60 days. Adakah majikan perlu memberi masa bagi unpaid leave? Yes, in this scenario, he will be on unpaid leave. He's not working. MC, HL, exhausted, sudah guna pakai, he will be on unpaid leave. Don't terminate him just yet. Put him on unpaid leave, monitor his condition, and decide at a later stage whether to frustrate or not to frustrate, right? But at this moment, he will be on unpaid leave. See, once the moment employee exhausts his hospitalization leave, he's on MC, or sick leave is on MC. Sometimes people like to ask this question. If MC finish, he's still on MC, can I give HL? No, HL is HL. MC is MC. 2 different things. So don't campur aduk, right? That's another favorite thing that people like to ask. Another favorite thing, I should have seen this earlier on, but whoever left the webinar, too bad for them lah, right? Now, sometimes when employee give you MC, and then they say, no, ini HL, doctor kata HL. So whose job is it to determine this? So when you go back, if you go back to Employment Act says this: the hospitalization leave as certified by the doctor. So the doctor need to certify it is HL, not for HR to decide, right? You need to tell the employee upfront, ladies and gentlemen, these are the company's medical policy. If you are on HL, you please get the doctor to write HL or endorse his HL. If you come and give HR at MC, HR will take it as MC because it is not my burden to go and do a PhD research to determine whether this is HL or SL. So you got to ask the doctor, as certified. What does Section 60F says? As certified by the doctor. So the HL to be certified. So please read the policy that I've shared. I've also mentioned there, it is their responsibility. So why you guys are like zombie, running here, running there, don't know what? Because you never make things clear upfront. You never communicate. So please read the policy, go through the policy, present it to your management, right? It's very tight. It's an airtight policy. Present the management, see if you need to modify anything, publish it, educate the employee so that tomorrow, if anybody gives an HL, they give MC, they say HL, you already made it clear. We've already told you that it's your burden, your job to get the doctor to endorse, not my job. It's your job. Got it? Okay. How about employee who's believed to be experiencing spiritual related, in Bahasa, what do we say? Sahun, is it? Santau, this, that, etc. Unfortunately, as far as company is concerned, as far as Section 60F is concerned, if the employee is unwell, doctor has got to give an MC. No MC from company's appointed doctor, or if you allow them to go to any panel clinic, right? No MC, annual leave or unpaid leave, right? That's it. Or if they're absent, absent. So either absent, annual leave, unpaid leave, nothing else. So, right? So like I said, go back to what Employment Act says. Nothing in the Employment Act, nothing here says that kalau kena santau, company mesti bagi whatever. No such thing, right? Santau is not here. So stick to what the law says. Okay, so maybe one last question. Okay, what if management not agree on separation scheme proposed by HR? Management sees employee issue. That's why I'm saying this. If you now terminate them on medical condition, you frustrate the contract, they can file a case as well. And if you're not able to prove and justify that your processes was done properly, you have done whatever you could, and the court is not convinced that you have done whatever necessary, be prepared to pay 24 months plus, right? So it's up to you. So I have personally handled numerous cases. Some people tried their luck. Some people lost the case. Some people we did out of court settlement, etc. Because they also know, right? So if you are very clear, very sure that you've done it correctly, if they file a case for unfair dismissal, you can still win the case. Go for it. But remember, I think I've made this statement a couple of times. The fastest way, the cheapest way, the safest way to terminate an employee for whatever reasons, unless major misconduct, right, is MSS. MSS is safer, faster, cheaper. Okay, so now, isn't it if that employee gets on MC, we need to convert to AL? I'm not sure, Dying, what are you saying? Isn't it that if he gets on MC and MC, we need to convert to AL? No, MC is MC, AL is AL. Not sure what you're asking, Dying, because I don't know the context of your question. Okay, last question. My staff got constipation, doctor gave MC, can we reject? Well, you see, again, if the doctor give MC, we should accept lah. But if this becomes very frequent, right, please get Dr. John to assess them. As simple as that, right? If this becomes frequent, please get Dr. John, right? Let Dr. John assess them. Throw the headache to Dr. John. Next. Okay, my last question. This is the last question because time is it's already 5:15. From one referral from a clinic, employee now have multiple appointments with hospital for 4 different medical conditions. He's using up all his MC for appointments. Can we check with the doctor why they gave MC for mere follow-up? You can try, but the other doctor may not respond to you. You can call, let's say if he's going to 4 different hospitals, maybe hospital A, hospital B, you can call, but maybe the hospital will not entertain you because they say, you know what, you're a third party, employee, patient privilege, confidentiality. So they may not. As I said just now, if you suspect anything, put them through assessment, right? He got to bring all his medical report and explain to Dr. John why he's on MC. So like I said, do not take this burden on your head trying to figure out, etc. If you see a trend, you suspect something, and this has been happening a couple of times, send for assessment. He's got to tell Dr. John, right? Dr. John is a doctor. So do that. Sometimes you never know. Employees will try to save their annual leave by trying their level best to get MC. As I said, you don't know what he's telling the doctor there. We're not there. We're not observing, right? We don't know. He may put on a big drama there, doctor, today I'm not feeling well, etc. Doctor say, oh yeah, you know what? Today morning, I was in the toilet for 3 hours. It is coming out, but never come out. Right? Constipation. Want to come out, but cannot come out. 3 hours I said I couldn't wake up and go to office. It was painful, etc. You don't know what he told, right? So if you suspect something is wrong, right, and you see a trend, send for Dr. John's assessment, please, right? This scenario or this approach works in most scenarios. Okay, so I think thanks a lot for joining us today. I hope the session has been super useful. So was it Eileen just now? Yep. Okay, Eileen, please, I hope you have got in touch with Yon. Done ready? Okay, good. So we'll courier this book to you. So, but for the rest of y'all, I would encourage all of y'all, this book, you can buy it from Popular, you can buy it online, get a copy because it's so useful. The Employment Act and all the regulations are there. Okay, so thanks a lot for joining us today. And we'll see you again in the next webinar. I think it is on Sarawak Sabah Labour Ordinance. Oh, okay. So yeah, our next webinar, sorry. Our next webinar is on Filipino hiring. For hiring Filipinos, there's a special DMD process or whatever. So we're having a webinar on that. We have June Marcus from Philippines, an expert in this area. So there's a webinar on hiring Filipino experts and getting this DM, I can't recall the process. So getting, those days we call it POEA. So now it's called DMW process. So for those of you, if you're hiring Filipinos, this is a good webinar to join. If you want to know more info, go to Facebook, search for it, sign up. And we have more webinars coming up. So thank you. See you so much. And please share the diploma to your employees who are working without diploma. If they want to get a career progression and job upgrade, promotion, this is a program they can do anytime at their leisure. Cost fee is quite low. So thank you so much and see you in the next webinar.